I'm here today to talk about handling employment investigations and all of the fun things that go along with that. One of the things that we want to do first, though, is to discuss some initial issues for consideration when you are faced with potentially investigating employee misconduct. First, as always, you want to have disciplinary rules in place that help provide your employees with notice of what you expect as the employer. Not only do they provide that expectation to your employees, but it also ensures consistency across the workplace, which is very important for reasons that we'll talk about here in a little bit. Secondly, another thing to keep in mind generally is that you want to address misconduct promptly. You don't want to sit on it, and there are legal reasons why that is the case. Generally, when you are thinking about potential disciplinary action, the reason behind that is to try to remediate whatever is occurring. And by not dealing with it promptly, then you are not engaging in those remediation efforts. And also, the longer that you wait, certainly it can create doubt if the action that you take is challenged, whether it be in front of an arbitrator or whether it be in front of a civil service commission or some other body. You also want to be fair, but obviously you also want to be firm. So generally, and we'll talk at the end about progressive discipline and what those principles mean, but generally what that means is that the discipline should fit with whatever the severity of the conduct was. So if you're dealing with something very minor, well then maybe you're looking at a written warning or perhaps a short unpaid suspension, whereas if you're looking at significant conduct, certainly if someone, say, assaults someone else in the workplace or engages in sexual harassment, as we've recently seen with Harvey Weinstein, if anyone follows the entertainment news, obviously then you might be looking at disciplinary action at a much greater degree. You need to be patient. This is very important because, what we'll talk about today is the process. What do you do if you suspect that misconduct has occurred, and how do you investigate it? Part of doing that, of course, is starting it promptly, but also being patient, waiting to be thorough so that when you do reach the end of your investigation, you have a pretty good basis for knowing what actually occurred, knowing that it could be subject to challenge. And then finally, you always want to get the employee side of the story. And depending upon the type of employee, we will see when we talk about Loudermill that there is a legal obligation on the employer's part to do that. So first we want to talk a little bit about what we refer to as the triple crown of employee disciplinary procedure. Some of you may have heard some of these terms. There's Weingarten, Garrity, and Loudermill. Clearly, these cases, which is where these names come from, these are cases that went all the way up to the Supreme Court. They provide some direction to employers in procedures that need to be followed as they engage in various facets of the investigation process. And we're going to talk about what each of those mean here in a little bit more detail.
Hey, Sean, based on the poll results, it looks like 67% of people haven't participated in a Loudermill meeting, 33% have.
Okay, well, very good. Well, then I think this is a good webinar for you to be attending. Certainly, if you have participated in a Loudermill, maybe you'll pick up some tips about some nuances in the process that maybe you haven't encountered before. And certainly, if you've never participated in a Loudermill meeting, this will help you understand at the very least the basics about what's expected, what's required, and how things work if you do find yourself facing a Loudermill meeting. So we will talk about that in more detail here coming up. So now we're going to talk a little bit about investigations. Specifically, the point of doing any investigation in the employment context is to determine what happened. And, I like to refer to the 5 W's, the who, what, why, when, and where. Those are the things that you want to try to determine as you go through your investigation. And the question is, how do you best do that and not run afoul of applicable legal requirements, particularly legal requirements that come about in the public employer context? So, the first case, and this is one of the 3 parts of the triple crown that I referenced earlier, is this Weingarten case. Now, Weingarten was a case that held for the proposition that if you have an employee who is a member of a union and you are interviewing them because you believe that maybe disciplinary action might result, if the employee reasonably believes that the interview may result in discipline, they have the right to have a union representative present. And that is what Weingarten stood for. Weingarten came from this case in 1975, and what the court said was that if you have a union employee, so just to be clear, Weingarten is a union right. So if you're dealing with a unionized workforce, which I imagine that many of you are, and if you are, you need to be cognizant of this case. You should know that if you're interviewing an employee and it's possible that they engaged in misconduct that might lead to disciplinary action, they should be provided the opportunity to have a union rep present. Well, what does that mean? Let's drill down on that a little bit and talk about some of the details relating to this obligation. So first of all, the employee generally has the right to select the representative. Now, a caveat to that is that the representative must be reasonably available. And I've definitely seen and talked with clients in the context of where they want to interview an employee. They want to know whether this employee perhaps engaged in some type of wrongdoing, which triggers their Weingarten right. The union employee then asks to have a union rep present, and they might ask for Jack. Well, maybe Jack's on a 3-week cruise in the Caribbean. Well, if that's the case, that's not reasonable. If, however, they ask for John, and John maybe isn't available today, but they're available tomorrow, or they're available in a couple days, well, then that probably is reasonable and should be permitted. So generally speaking, the employee does have the right to select their union representative, but it cannot unduly upend or in any way put the employer out, because the employer clearly has the right to engage in this investigatory interview. Also, it's important to know that the representative, the union rep who's there, they are permitted to speak, they're permitted to advise the employee. However, they're not permitted to obstruct the investigation. So if the union rep comes in and says, whoa, 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 we're not going to allow this to go forward, that's not their role. And they can be advised and should be advised that that's not their role. And in fact, the employee should be advised that their failure to participate in the process could constitute a separate basis for disciplinary action. And then also, the other thing that I wanted to note is that the employee is the one who is required to answer the questions that you're posing as the employer. It is not the union representative's job or obligation to answer questions on behalf of the employee. Some other things that apply in the Weingarten context, I always, and I know other attorneys in my firm always advise our clients that, look, if you know that the interview with a particular employee could lead to disciplinary action, well, just advise the employee of that from the outset, so that if they do want a union representative, they know that they should go get them and bring them in, so that when you do conduct the interview, you're not potentially depriving them of some right that they have. The other thing that I would say, and this is the second bullet point here, sometimes it's the case where you might be engaging in an investigation, and through the course of your investigation, the person that you're interviewing you believe might just be a witness, but maybe did not engage in any misconduct. Well, it's certainly the case that that could change as you talk to that person. So if, as you're talking to a person who you initially thought was just a witness, but you now learn that maybe they engaged in conduct that could lead to discipline, then you should stop. You should inform them of that fact. And if they're a unionized employee, they should be provided the opportunity to obtain a union representative, so that there's no claim that can be given rise to an idea that we have somehow violated their Weingarten rights. And then finally, if the employee refuses to have a union representative present, I would advise you to get that in writing. I have seen that happen a couple times, and the context within which that generally occurs is that maybe the employee engaged in conduct that is embarrassing in some way, and because they feel that it's an embarrassment to them, they don't want their union representative to be aware of it, because then they believe perhaps rightfully, that that conduct will become known to all of their other coworkers. That's where I've often seen a unionized employee decline to have a union representative present in an investigatory interview. So those are the basics about Weingarten. One thing that I think we should talk about as we're talking about the investigatory process here is that the employers do have rights. Not only do the employees have rights, of course, we're talking about the Weingarten right. There's the Garrity right. There's also Loudermill, which we'll talk about here in a little bit. But employers also have rights, and those are significant rights. Specifically, you have the right to ask questions of your employees. You have the right, and in fact, you have the obligation to investigate alleged wrongdoing in your workforce. So as part of that right to engage in an investigation, not only do you have the right to do that, but your employees are obligated to answer your questions and to answer your questions truthfully. You may run across, and perhaps some of you have done this already, perhaps you run across the scenario where you want to talk to an employee about potential wrongdoing and they claim to have a Fifth Amendment right against self-incrimination. Well, you know, obviously they've been watching some Law and Order or some other TV show that leads them to believe that they don't have to answer your questions. And fortunately for employers, they're just wrong. Clearly, in the employment context, the courts have upheld this idea that employees have an obligation to participate in a reasonable employment investigation, and they have an obligation to answer your questions truthfully if they know the answers. The other thing that I want to note is at the investigatory stage, you do not have to share information with your employees beyond what they need to know, and you can use that to your advantage, and we'll talk about that here in a second. But the other thing, and this goes back to what I was saying about employees having an obligation to participate, if they fail to either answer your questions or to answer them truthfully, those can constitute separate bases for potential disciplinary action. So that is something that you should use to your advantage if that does in fact happen. So, you know, we've talked about the scenario where perhaps you've become aware that an employee has engaged in misconduct. You start this investigatory process. One of the things you should ask yourself is, who is the appropriate investigator as you progress with your investigation? You know, is it going to be the direct supervisor? Is it going to be someone in human resources? Or is it going to potentially be a third party? And I think, you know, the answer to that question is going to vary depending upon a number of factors. Some of the things that you need to look at to determine whether someone is an appropriate investigator include these things that we've listed here as bullet points. You know, do they have the requisite knowledge, skills, the credibility, objectivity, and the ability to maintain confidentiality that you need for someone who is going to engage in an employment investigation? Those are things that you should ask yourself before you begin. Secondly, I do think that determining who the appropriate investigator is depends sometimes on who the alleged harasser is. So certainly if the alleged harasser is the borough manager or the township manager, or, you know, the primary manager in whatever type of municipality this might be occurring, it doesn't always make sense to have a subordinate employee undertake the investigation, or certainly it wouldn't make sense to have that person undertake the investigation. And if that scenario were to arise, you might want to consider using a third party, whether that's your solicitor, your labor counsel, or some other party that has the requisite skills and knowledge to do it, but who also is not in a position to be swayed in some fashion by the imbalance of power or authority between the investigator and the alleged perpetrator of the misconduct. So you also need to look at the nature and scope of the investigation. You know, clearly you should always keep in mind that the investigation should have some endpoint. You know, in my opinion, you need to start the investigation quickly, but there shouldn't be some false limitation on the time frame within which it needs to be completed. Sometimes, and I've seen policies from employers who have said it has to be done within, say, 5 days. Well, sometimes 5 days just isn't realistic, especially if you're trying to get information from another source, an outside source over whom you have no direct control. That just might not be workable. Ultimately, what's most important is that your investigation is thorough and that it considers all sides and all relevant evidence. One of the other things you should think about is if you have potential employee misconduct that rises to the level of criminal conduct. So say you're investigating an accounting clerk who is alleged to have embezzled money from the municipality. Well, obviously, that would be something that would be outside the scope of what you expect as an employer. It would violate your policies, but it also could potentially lead to criminal action for theft or embezzlement. So in those scenarios, and we're going to talk about this in a little bit when we talk about Garrity, you need to think about whether there should be a delay. Certainly, if criminal charges are pending, it's the case that they might have to go to a preliminary hearing and they have an arraignment and they have these other criminal procedures that they have to adhere to. Do you wait? The answer generally, or almost universally, is no, you should not wait, and we'll talk more about that here in a minute. And then what about the presumption of innocence? That's certainly something that is a concept in the criminal context, and it certainly applies in the criminal context, but in the employment context, your standard of proof is a little bit different. And again, we're going to talk about that here in a second when we move on to Garrity. So when you're thinking about your investigation and the process that you're going to use and who's going to do it, one of the other things that you need to be thinking about is, well, what should I be looking at? Obviously, you want to talk with people who have firsthand knowledge about what occurred, but you also need to be mindful that there are potentially relevant documents that you could review. Clearly, rules, policies, and procedures, those are the things that you would rely on as a basis for any disciplinary action that might result. To the extent that you could determine someone violated those policies, you should be looking at the personnel files of the individuals to determine whether there was any prior conduct that was objectionable. This can play into, again, once you get to the point where you determine that disciplinary action might be necessary, that could serve as a basis for determining how severe the punishment should be, especially in light of the fact that generally, especially in a unionized environment, you're looking at a progressive discipline track. You need to be looking at phone records and text messages. In today's world, I know that this is a whole cottage industry that has sprung up in litigation, particularly in federal court litigation, where e-discovery has become a huge factor. I had a federal court case a couple years ago where it was an employment discrimination claim, and as part of that discovery for that case, I had to review 1.6 million emails that were attributed to 16 different people, undertake a review of all of those for relevant evidence. We ended up supplying to the other side approximately 5,500 emails, after which we had undertaken a privilege review to make sure that there wasn't anything in there that was potentially privileged. So clearly that was a very substantial effort. Not every case is going to have that many emails. Some cases, some of these big corporate cases have many, 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 many millions more. But the point is, in today's world, e-discovery is something that we always need to be mindful of, because communications, more often than not, are now sent electronically rather than in hard copy. So not only does that include text messages, phone records, voicemail messages, but also clearly emails. So please be aware that all of these various areas can serve as potential evidence for you in your investigation. So also, when you're considering the scope of the investigation, you need to be thinking about, how do you secure the evidence? If it's an email or a text message, what steps do you need to take to make sure that that evidence isn't lost? That's going to vary depending upon where the text message is housed, where the emails come from. Certainly you can send a letter to someone who might be the target of an investigation, informing them that they have an obligation to preserve relevant data, which can include text messages and emails. Obviously, if it's on a employer-owned piece of property, such as an email server or a phone, you can preserve that in a way that it will be there when you need it down the road. You need to think about who's going to be interviewed and what the rights are of the interviewees. We talked about the Weingarten right. Clearly, if someone feels that disciplinary action might result, they have the right to have a union rep present. Who do you interview? You obviously want to talk with anyone who might have firsthand knowledge about what occurred. And then I have here a note relating to the after the fact investigation. This doesn't always happen, but sometimes it comes up that you don't learn about something until maybe 3 months after it occurred. And I know sometimes, I'll get a call from a client and the client will say, look, I learned recently that so-and-so did X, Y, and Z back in March. I didn't know about it at the time. I just learned about it. I don't know that there's that much that I can do about it now. What should I do? Well, my answer is always, you need to follow up on that. You need to conduct an investigation, because clearly if anything were to come of it, if any liability were to result as a result of that prior conduct, the question that you would be asked in the context of that litigation is, well, once you became aware, what did you do? And you always want to be able to answer the question by saying, well, we conducted an investigation and we found out whether there was any merit for potential discipline. So just because it may have happened sometime in the past doesn't mean that we just throw our hands up and say, well, it's already done, we can't do anything about it now. So as you're preparing to conduct the interviews, there's some things to think about. One, obviously you want to prepare. You want to put together questions. You want to think about the order of interviews. In my opinion, you should use that to your advantage. I generally like to talk to other witnesses who have firsthand knowledge about something before I talk to the person who allegedly engaged in the misconduct, because what I will do is use the fact that they don't know what I know to my advantage when I talk to them. And that's completely acceptable. The labor board, if we're talking about a unionized employee, the labor board has determined that obviously you can't harass or interfere with the union relationship as part of your investigation, but you clearly can engage in advanced investigative techniques, which means, asking questions in a way that's designed to elicit information that you might not otherwise have. You want to have a detailed outline of your questions in place before you start your investigation, but you also need to be prepared to listen. That's the most important thing, is when you're doing these investigations, you need to listen and make sure that you are prepared to pivot to other questions and other areas if you need to, based upon what the employee is telling you. Okay, so you've gone through all of these steps. Now it's time to conduct the interviews. What do you do? Who should be there? Well, certainly the person who's conducting the interview needs to be there. They need to be prepared and all of those things that we've just talked about. But we always advise that the investigator also have another person available for the employer who would really serve in two different roles. One is they would potentially serve as a witness in some later proceeding, whether that be a grievance arbitration or whether it be a civil service hearing or whether it be litigation, certainly. And you also, of course, want to make sure that that person is taking some notes. They should be taking notes in a way that is beneficial to the employer. That will allow the person who's actually conducting the interview to focus on the questions and allow them to actually listen to the answers that are being provided. And then finally, you also need to be mindful, as we talked about, of any Weingarten rights. So when you get into the interview, what do you do? In our opinion, there's a couple things you should do. One, you should tell the person who's being interviewed why the interview is taking place. Now, that doesn't need to be an exhaustive recitation of everything that you know. It's just generally, listen, we're aware that X, Y, and Z occurred. We are obligated to investigate this because we believe that it may have violated our policies. And then you advise the interviewee of his or her role. So if they are a person who you believe engaged in wrongdoing, you should tell them that at the outset. If not, if they're merely a witness, then you could tell them, look, as far as we know right now, we believe that you were a witness to this. We don't believe that you were engaging in this conduct. Obviously, if that changes at some point, as I mentioned before, you should stop and inform them that now you believe that maybe they did. And if they have this wine garden right, then they should be permitted to have their union rep present. You can tell them how the information might be used. Certainly in an investigation, they should be on a need-to-know basis. Some employees may need to know more than others, but it's not your role to share what everyone is saying to everyone else. That is for the employer to gather so that it can make an informed decision once the investigation is complete. You can also talk to them about the seriousness of the investigation and the importance of accurate information. This gets back to what I mentioned before. They have an obligation to participate and to participate truthfully, and you can inform them specifically of that obligation. Some appropriate question formats. This gets back to what I was talking about before with the advanced investigative techniques. You can ask open-ended questions. You shouldn't generally ask compound questions. What you don't want to do is to confuse the people who you're interviewing. You're on a fact-finding mission at this point, so you're trying to ascertain what happened, and sometimes the best ways to do that is just to say, okay, I understand that you were in the lunchroom on August 3rd and that something happened. Why don't you tell me in your own words what happened that day? And then that's a very open-ended question. It gets them talking, and then as they start to go through the narrative of what occurred, you can certainly prod them with more specific questions as that develops. As I said before, you should ask questions based on the answers that they're receiving. And then, sometimes you can save the tough questions for the end. It depends on each investigation how you want to do that. We should talk a little bit about confidentiality. I know I touched on it before. Generally, you want to provide information to others who need to know. So for instance, after you complete an investigation, if you haven't already spoken with the direct supervisor of the person who might be subject to disciplinary action, clearly you'll need to talk to them, let them know that you've engaged in this investigation and that the employer has determined that some disciplinary action is merited. You will need to let them know that so that they can plan accordingly from an administrative perspective. What do you do if you have a complainant who came to the employer and that's what prompted the investigation? Well, we generally recommend that you check back in with them. You let them know that there's an investigation occurring. And then if appropriate action is taken as a result of that investigation, we generally recommend that you tell them just that appropriate action has been taken as deemed by the employer. I don't generally recommend that you share a lot of detail about what specific disciplinary action results, because remember, generally speaking, personnel matters are confidential, and you want to maintain that confidentiality, but you should be able to tell them at least that you're investigating the matter and that appropriate action has been taken. What do you have to tell the employee who's under investigation? Not really very much at this stage. You have to inform them that you believe that maybe disciplinary action could result based upon what you know, but you don't have to give them a lot of information right now. This last question is, what do you have to tell the union? What I would tell you is, as always, if there is a unionized workforce that's involved in the investigation, you need to consult at the outset your collective bargaining agreement to make sure that you are complying with any collective bargaining provisions that might apply in the investigation context. So now we're going to talk about a few frequently asked questions. These are ones that, my firm, we have two offices, one here in Pittsburgh and one in Philadelphia. We only practice in the area of labor and employment law, and we specifically practice primarily for public sector employers. So what we've done is, kind of put our heads together and came up with some questions that we get very regularly from clients who maybe haven't had to deal with these types of scenarios very often, and that's what we're going to go over here. So first of all, an employee files a complaint but asks for total confidentiality. What do you do? Well, as we just talked about, we have a duty to investigate complaints. We, as the employer, cannot promise complete confidentiality. However, we can tell the employee that we will maintain confidentiality to the greatest extent possible, and that we will really just share the information that we learn with other people who are on a need-to-know basis. Next, an employee files a complaint. An employee tells an investigator about a number of serious acts of misconduct, but refuses to divulge any names. What do you do? Well, in this scenario, the employer should tell the employee that they have an obligation to tell you the names. And where that comes from is, if once an employer becomes aware of alleged wrongdoing, it has an obligation to conduct an investigation. So if you have an employee who apparently feels that there's wrongdoing occurring, they also have an obligation to tell you who the alleged wrongdoers are, and then you can investigate from there forward. Another frequently asked question that we get is, a lengthy investigation has just concluded and the bottom line result remains the classic he said, she said scenario. What action do you take, if any? And unfortunately, this does sometimes occur. It's possible that misconduct is alleged and the only two people who are witnesses are the two people involved. This sometimes happens, for instance, in a sexual harassment type of allegation. And that becomes very difficult, but ultimately the employer is required to make a credibility assessment. So you speak with the two individuals, you look to see whether there's any other evidence available, and you assess which one appears to be more credible, and you make a decision based upon that determination. Ultimately, if it ends up in some other type of context, if it's challenged, so for instance, if it goes to an arbitration or if it goes to a civil service hearing, or you end up at the EEOC over the matter, they will be doing the same thing. Those other bodies will be doing the same thing. They'll be making a credibility determination, and that is, in my opinion, something that you as the employer should be doing in that scenario. Another frequently asked question is, a material witness to the investigation refuses to speak to the investigator without his or her personal attorney. What do you do? Well, this is a question that we very commonly get, and our position is that a personal attorney has no place in an internal employment investigation. You should explain that to the employee clearly. If there is a collective bargaining agreement in place, you should consult it. I have seen collective bargaining provisions, specifically ones for police officers, if they have a Bill of Rights provision, which do sometimes provide the ability for a police officer who's under investigation to bring in a personal attorney. We do a lot of collective bargaining in my firm. I do it myself personally as well. When I am confronted with these proposals from the employee side, I always have a conversation with my client, the employer, about why that's not a preferable term or provision for their collective bargaining agreement. But clearly, if there's something in your collective bargaining agreement that requires you to do that, then you have to follow it. Otherwise, there is no obligation for an employer to allow an employee to bring their private attorney into the workplace. The one caveat to that is if they're a unionized employee, if the union representative is a lawyer, then they have a right to have that person present. The real distinguishing difference here is no personal attorneys should be permitted unless otherwise required. So, okay, we've talked a little bit about the basics. We've talked a little bit about the process. One of the things that you should sometimes consider as part of your investigation process is obtaining written witness statements. And we're going to talk about why that can be important, and I try not to share too many war stories, but sometimes I think they're illustrative of why we make the recommendations that we do. The purpose of a witness statement, there actually are several reasons why you might want to do it. One, you want to preserve information for later. And, certainly in today's world, we know that employees as a group tend to be litigious. Employment claims constitute one of the highest numbers of claims in the courts today. Because of that, I think that when disciplinary action, certainly anything that rises to the level of suspension, demotion, or termination, you should foresee that it's going to be challenged in some context. So one of the reasons why you might want to get a witness statement is you're asking the witness who has firsthand knowledge about what occurred to provide a written witness statement at or around the time that the conduct occurred. So it's of course going to be fresh in their mind at that point, and it's something that they could use to refer to later down the road, especially if litigation were to result. Litigation could occur a year to 2 to even 3 years down the road before it really becomes part of what the employer would need to present. So that's one reason. The other 3 bullet points here, I think, are all related. We have on here to lock up wobbly witnesses, to lock in potentially adverse witnesses, and to counteract union pressure. This is very important in certain contexts, and I'll tell you the one where I've actually dealt with this issue. If you have a potential disciplinary matter and all of your witnesses are fellow union members or fellow employees, and you don't have any management employees who perhaps observed what went wrong, I can tell you that you should get a written witness statement from those employees. And here's why. I had a case about a year ago where it was a borough. There were public works employees who were alleging that a fellow public works employee was doing things that were outside the expectations of conduct of the borough. And unfortunately, the borough was of such a size that there was no public works director, no management employee who was there to observe it. The things that were being alleged came strictly from the fellow union employees who were tired of having to deal with the antics of their coworker. Well, knowing that that could be an issue because they were a unionized workforce, when I was helping the borough through the investigation, I advised them to get written witness statements from each of these fellow union members. And I'm very glad that I did that because, lo and behold, the day of the arbitration hearing, the stories that they were wanting to tell to the arbitrator were much different than what they had told the employer in the course of the investigation. What I came to learn that the representative for the union had called them all to a bar the night before the arbitration and had a stern talking to them about what their expectations were relating to their fellow union employee. Had I not had those written witness statements in the arbitration, it very well would have resulted in the employer not being able to uphold the disciplinary action. But because the employer did have those written witness statements, we were able to use those to impeach the witnesses on their own testimony. They were held to the fact that they had put that in writing, and fortunately the employer was able to prevail, which meant that the disciplinary action that they had meted out against the employee was upheld. So, there can be some real good reasons why you should get a written witness statement, particularly in that scenario. So what are some things that you should think about when you're taking a witness statement? I mean, one, you want to know why you're doing it in the first place. What information can they add? So certainly it should be someone who has firsthand knowledge about what occurred and what you're investigating. You should also think about whether it's a potentially favorable witness or someone who might be an antagonist, someone who would testify against your position. Certainly if they're willing to give a written statement, it can be helpful even in that scenario, because sometimes, and again, I'm not saying this happens with everyone, but I have seen in a hearing where there's been some, shall we say, embellishment added to the alleged wrongdoing. And even when you have a written witness statement from someone who you knew to be an adverse witness, you can hold them to the statement so that the alleged wrongdoing that was perpetrated by the employer isn't quite as severe as what they're trying to make it out to be. You can also use the witness statement to build their credentials, to establish credibility, particularly if the employee who is providing a statement has some type of special experience or background in the area that you're asking them to give the statement. So these are things that you should think about. Ultimately, what's most important is that if you're going to take a witness statement, be sure that you can use it. I mean, here, and I don't know if you guys can see this on your screen, I hope that you can. It's just a bit of a lighthearted illustration of this concept. It says, you're our only eyewitness. Is this the very best you can do? And here you have the the lady here in the cartoon is depicted as drawing the person who is alleged to have perpetrated some type of wrongdoing, and it's a stick figure. So obviously that would not be very useful really to anyone. So if you're going to get a witness statement, make sure that it has some value.
I'll go ahead and launch that video.
I was putting one more tap of coffee in my coffee cup, and out of the corner of my eyes, I saw two guys come in, one with a black hoodie, one with a white hoodie. And the guy with the black hoodie said, "We want your money, everybody up front and down." And I'm like, oh, why did I need coffee now? And so the guy in the black starts coming down, and I'm like, don't look, don't look, don't look. So I'm putting my hair down, you know, and he comes right to me and he goes, "Get down now." And I go, "Yes, sir." And I just dropped to my knees, see my little knee. And then when I'm on my knees, I'm backing up, backing up, backing up, backing up, backing up, backing up. Because my daddy taught me good, and I'm backing the hell out of there. And then when I figure I'm safe, I'm like counting to 2,000, and I don't hear nothing. Then I hear boom, boom, boom. And I'm like, oh my God. So I back farther and farther away. And I think maybe I should faint, but I don't. And so then I'm thinking, count to 2,000 again. So I did. And then I go, "Mi amigos, mi amigos." Nobody said nothing. I'm like, oh my God, they're dead. I'm like, I'm going to have to find all my friends dead. And then they were laughing. They shot the rubber. He's a hero. Saved all three of them.
Okay, so clearly there we had a clip of an eyewitness, and you know, if you could respond, and I know, you know, given that we're doing this in a webinar format, that's difficult to do, but you know, the question that I would pose is, do you believe that this person was a helpful eyewitness or not? And I think most of us would agree, you know, even though she very colorfully described what occurred, she likely wouldn't serve as a very great eyewitness, given that the details that she was providing were much more about her reaction to what she saw than what she actually saw. So, you know, this just hopefully illustrates the things that we've been talking about. How is the witness furthering your case? Are they speaking to the 5 W's, the who, the what, the why, the when, and the where? And if not, you know, you should think about whether you need to use that person as a witness or not. So, you know, if we're looking at good witness statements and general rules for it, there's a couple of things to keep in mind. You know, you want it to be contemporaneous. In other words, it should be at or around the time that the conduct occurs. It should be something that they're offering in response to the relevant event. Is it chronological? So in other words, is the statement presented in a way that is understandable, when it's read by someone who knows nothing about the investigation that's being undertaken? Is it specific on the essential points? This is the 5 W's. And then, of course, you want it to be legible or understandable. If someone has poor handwriting and you know, you ask them to write it up, you may want to consider typing it for them and then asking them to sign it, making sure that they attest to its accuracy and veracity. Okay, so next we're going to move on. We're going to talk a little bit about Garrity. We talked at the outset of the presentation about the Triple Crown, the first being Weingarten. This one is the second part of that. It's called Garrity. This case and the rights that come out of it apply whether you are a union employee or a non-union employee. So that's very important to keep in mind. It only applies in the context of an employee who engaged in conduct that also is potentially considered to be criminal in nature. And what Garrity did, Garrity was a case that went to the Supreme Court, and it had to do with I believe it was a police officer who had engaged in conduct where they were also being charged with a crime. And Garrity stands for the proposition that if you have an employee who is in that situation, obviously you as the employer, you want to undertake an investigation to determine whether that person should be subject to disciplinary action. Well, because they're subject to a potential crime in a criminal investigation, they do have this right to not incriminate themselves, which is the Fifth Amendment right. So what the Garrity court held was, if you are an employer conducting an employment investigation of an employee who engaged in wrongdoing that's potentially criminal in nature, they have this Garrity right, and we're going to talk in more detail about how we advise them of that right and what it means. But essentially, it means that if you inform them of their Garrity right, they have to tell you what occurred in response to your questions. So in other words, you can ask them the questions, they have to answer, and they have to answer truthfully, but you cannot take that information that they provide and give it over to the DA or the Attorney General or whoever it is that's investigating the criminal conduct. So it preserves their right against self-incrimination. That's how it protects the employee. But for the employer, it allows the employer to move forward with its investigation without being faced with the scenario where the employee could say, I'm not going to answer your question. So let's talk about that in a little bit more detail.
Sean, we do have a poll up right now. It says, does the Garrity case mean that an employee has the right to remain silent in an employment investigation by their employer? It looks like everybody's split between yes, no, and unsure. There's no clear winner here.
Okay. Well, thank you, Justin, for that. So to be clear, the Garrity case does not mean that the employee has the right to remain silent in an employment investigation. An employee who is being faced with potential criminal conduct, when they are informed of their Garrity rights, they have to answer your questions as the employer. So it does not allow them to invoke their right to not testify. It also means, as I said, that the employer cannot take the information that they provide to you and turn it over to the AG or a DA, because that's the part that is protected. So after Garrity warnings are administered, employees must answer your questions. If not, they'll be subject to discipline, which can include termination, just like in any other context. I would note that Garrity cases often involve police officers, but that's not always the case. Any employee who has engaged in misconduct that potentially rises to the level of criminal conduct can be subject to Garrity. I mentioned before the example of an accounting clerk who is being accused of having embezzled money. Clearly, Garrity would apply in that context. And as I said before, it applies to both union and non-union employees. So what we often advise is, if you know that an employee is in that situation where maybe they are accused of embezzling money and you want to go talk to them to learn what occurred as they would tell you, in other words, you're engaging in your employment investigation. At the outset, I normally advise that you inform them of their Garrity rights. I actually have a written statement that I provide to my clients. That it's just a half page. It says that under Garrity, you have to talk to us, but you also recognize that we won't share what you tell us with the authorities for purposes of your criminal investigation. And then you ask them to sign off on it so that then you have a record that you've actually had that discussion before your investigation begins. Garrity often raises the question of, well, if we know that someone might be subject to a criminal investigation, shouldn't we just wait for that to play itself out? And my answer is always, no, you should not. There's several reasons for that. First of all, you have no idea, if you decide to wait on the criminal justice system, you have no idea how long that's going to take, for one, and you don't have any control over it, for two. So, they could plead down, there could be delays, there could be requests for continuances. There are all kinds of things that could happen that could serve to make this a very lengthy process. And if you decide to wait, then you're stuck during that entire time dealing with an employee who maybe did something that you really don't like without any end point in sight. Secondly, another reason why, in my opinion, you should not wait is that the standard of proof in the employment setting is much lower than in the criminal context. Obviously, in the criminal context, a district attorney or an attorney general, depending on who's investigating, would have to prove beyond a reasonable doubt that the person engaged in the criminal conduct. Well, you don't have to prove it to that high of a standard in the employment context. Even in a just cause setting, you have to prove that it's more likely than not that they engaged in the conduct that you believe violated your policy. So that's another good reason to not wait for the criminal investigation to wind its way through. So you should always do your own investigation and reach your own conclusions. Okay, so that covers parts 1 and 2 of our Triple Crown. The next one is Loudermill. You guys have probably heard the term. I know we did the poll earlier, and some of you have been involved in a Loudermill meeting, some of you have not. Loudermill comes from this case, Cleveland Board of Education versus Loudermill. It went to the United States Supreme Court back in the mid-'80s. And essentially what Loudermill stands for is that if a public employee who has a property interest in their employment, and we'll talk about what that means in a minute, if they are potentially subject to discipline that would deprive them of either, say, pay. So in other words, if you have a public employee who's going to be suspended without pay, demoted, or terminated, prior to that disciplinary action occurring, they have a right to notice of what they allegedly did wrong and an opportunity to respond to that alleged statement of misconduct. So let's talk a little bit more about what that means. So first of all, an employer has to meet with the employee prior to making a decision that relates to, as I said, an unpaid suspension, a termination, or a demotion, and tell the employee what they did that they believe violated the employer's policies. The employee must then be given the opportunity to respond. If the employee is represented by a union, it's important to note that the employee has a right to have the union representative present. Just to really simplify this, the essential elements of a Loudermill requirement are that there's notice to the employee, they have an opportunity to respond, and that this is done before you make a disciplinary decision. So the question is, what do you have to tell them? What is the notice of? Well, it should be reasonable notice, enough to allow the employee to understand what they were alleged to have done wrong. It does not need to be every detail. You don't have to provide a written report. The only caveat to that would be as if your collective bargaining agreement dictates otherwise. As I've said before, at the outset of any investigation and certainly prior to any disciplinary action, you should be very aware of what your labor agreements say if you have one relating to potential misconduct. Secondly, they have to be provided an opportunity to respond. That's not to say that they have to do so. So, don't conflate Loudermill with Weingarten. With Weingarten, as I said, at the investigatory stage, you can compel them to answer your questions. And if they don't do that, then they risk doing it at the peril of other disciplinary action. At the Loudermill stage, however, you've already conducted your investigation, and this is just your last check before you decide what disciplinary action is going to result. So at this stage, even though you have to provide them the opportunity, they don't have to actually respond to you. They should, and generally speaking, they do, but they don't have to. So, Loudermill is designed to provide a minimum level of due process before they are deprived of some property interest in their employment. It's intended to ensure that they're afforded this due process. It doesn't require a formal proceeding, and you may have heard Loudermill referred to as a hearing. Well, it's not a hearing, it's a meeting, and it can be undertaken verbally. It can be fairly low-key. Certainly the union representative needs to be there if that's something that's in place, but it does not need to be a formal hearing. Now, who does it apply to? We talked about this before. So it applies to employees with a property interest in their employment. Property interest means that they're, one, either covered by a collective bargaining agreement, so they're a unionized employee. Perhaps they're civil service. If you have a civil service employee, there clearly creates a property interest, which means that they have this Loudermill right. Or if they have some other termination for cause protection. So it could be the case that you have an employment agreement that says that someone can only be terminated for cause. Well, if that's the case, then in my opinion, you would have to provide the Loudermill meeting before any disciplinary action can occur. A couple of things to keep in mind. Even though it's commonly thought that part-time employees might not be covered by a collective bargaining agreement, the labor board always takes a position that they are if they are regularly employed. So again, when we're looking at unionized employees being subject to this right, your part-time employees are likely also covered by this obligation. In my opinion too, and this goes to the second bullet point, it's a best practice. It's a good practice for the employer to provide this Loudermill meeting for anyone who it's thinking of disciplining. It doesn't really harm the employer in any way. If anything, it just provides greater protection to the employer if an employee, regardless of whether they're union or not, or civil service or not, if they decide to in some way challenge whatever disciplinary action results. So we've talked a little bit about what Loudermill is. What is it not? As I've said, it's not a hearing. It's just a meeting. Hearings are formal. Loudermill does not have to be formal. It's strictly notice and an opportunity to be heard. Next here we have a Venn diagram that we put together that compares the two types of processes. We have Weingarten on the left and Loudermill on the right. And then you see in the middle there the overlap between the two, where there's a right to have a union representative present in either scenario. Now, obviously, as we've talked about, Weingarten is an investigatory phase. The employer is not required to give information at that point, and the employee has to answer the questions that the employer poses. At the Loudermill stage, which is the pre-disciplinary phase, that's after you've completed your investigation, the employer has to give notice, and it has to give the employee an opportunity to respond. So who should attend a Loudermill meeting? Again, from the management side, certainly the person conducting the meeting, they need to be there and invested in what's going on. There should also be at least one other person attend for management. Again, their role is twofold. One would be to serve as a potential witness in a later arbitration or some other type of proceeding, and also for them to take notes. They should take notes of what's being discussed at the meeting, and they should do that in a way that is advantageous to the employer. On the union side, who should attend? The employee. I mean, in my opinion, yeah, the employee should always attend. As I said, they can't be compelled to, but they should. The union, yes, obviously if the employee indicates that they're going to attend and they want to have a union rep present, then that union representative should be permitted to attend. And then lawyers, we talked before about it. Certainly if the lawyer is a union lawyer, then they should be permitted to attend, but if it's a personal attorney, then my opinion is that they should not be permitted to attend. So on that score, we talked about the fact that personal lawyers are never allowed, but if the lawyer is a representative of the union, the labor board has taken a position that they have to be permitted to attend because they're attending as the union representative and not necessarily as a lawyer. So I think next we have a poll coming up.
You know what, I was running it while you were talking about it and you answered the poll during it. It says, does an employee have the right to bring their personal attorney at a Loudermill meeting? And 100% of everybody said no.
Great. All right. Well, I appreciate you guys listening. That's the right answer. So, just to summarize, Loudermill meetings, you need to meet with the employee, you need to let them know what you believe they did wrong. You need to provide them with the opportunity to tell their side of the story. The meeting must take place before discipline. You should not say anything at the Loudermill meeting which would suggest that you've already made up your mind about what degree of discipline might result. So in other words, you should not go into a Loudermill meeting and say, I'm going to terminate you, but this is what I have to do. You may have in mind that that's what you think you might do, but you should not convey that to the employee because the Loudermill meeting is supposed to be a pre-disciplinary meeting. And then the other thing, and I have this last bullet point, if you get it wrong, you must rescind the discipline and do it over. If there's a procedural error, so in other words, if you Learn new information during the Loudermill process that didn't serve as an initial basis for discipline, but you believe that it should. And maybe say you have further investigation to do, well then stop the Loudermill, go back to the investigative process, complete your investigation, and then come back and do your Loudermill and include that as an additional basis for your Loudermill meeting. It should not be a rush. It should be more about doing it correctly. As we've said, some Loudermill and Weingarten tips. You should have 2 management representatives present. You want to have an employer witness. One thing to keep in mind is that if you have a note taker in the Loudermill process, there is a labor board decision which has stood for the idea that if the union requests those notes, the employer has to provide those notes. So the person who you have taking your notes should be aware of that. They should not be doodling or making sarcastic comments in their notes or making inappropriate comments in their notes about the employee or the employee's representative, because it's certainly the case that if the union asks for those notes, which they often do for some later proceedings, such as for an arbitration or for a civil service hearing, you have to provide them. So use that to your advantage as you have those notes taken. And ultimately, the most important thing, this is the last bullet point, you should have your questions planned in advance because this goes to being prepared, but you should also, above everything, listen to what's being said and be prepared to pivot based upon the information that's being provided. So finally, before we wrap up, just a couple of things that I think we need to talk about before you decide to impose discipline. You need to consider several things. One, are you being fair? Obviously, you should consider whether employees who have committed the same or a similar offense have been punished to the same degree that you're considering discipline for the particular employee in front of you. If not, I can tell you that that would serve as a basis for challenge if you have to go to a labor arbitration or if you have to go to a civil service hearing. If you are being inconsistent in your discipline without good reason, it can be a basis for having it overturned. It also can create liability in an employment discrimination context, because certainly the EEOC, if they get involved with an investigation and say someone says that, well, I'm over 40 and I did the same thing so-and-so did who's 25, and me, the over 40 employee, I got a 3-day suspension and all they got was a written warning, well, you can bet that the EEOC would look at that to see why there's such a differentiation between the two different disciplinary actions. And then this bullet point on this slide, the last one on this slide is, are you acting promptly? As I said, if not, it creates a basis for challenge and arbitration. An arbitrator is going to want to know why, if you believe something was so severe as to merit disciplinary action, why did you sit on it? So, clearly you want to deal with problems promptly after they occur. Some other questions you should ask yourself is, have you identified the policy that you believe to have been violated? This is something that I think highlights the importance of having written policies that provide your conduct expectations. Can you prove that the employee had notice of the rule? One of the things we often recommend in an employee handbook, for instance, is to have a signed acknowledgement agreement so that the employee signs off that they've actually received, read, and understood the policies that are set forth in the employee handbook. It's also important, in addition to that, to provide periodic training to your employees, again, so that you know that they're aware and understand what your expectations are. If you have trainings, which I do recommend, you should have sign-in sheets for those so that you have a record, again, not only of the acknowledgement that they've received the policy, but that they've also attended training, and therefore they should not be able to say reasonably that they didn't know that there was a policy or that they don't understand what the policy says. Obviously, this entire seminar is about gaining evidence to support any disciplinary action, so that goes to the next point. Obviously, you want this to survive challenge, recognizing that there may be a challenge to whatever action you take. And has the policy, rule, or regulation been routinely enforced? This often comes up in the context of a tardiness rule or an absentee policy. If it's been the policy of the employer to let things slide, well, that can be very difficult. to address if you at some point change your mind and the employer wants to start really enforcing that in a strict fashion. If you're going to do that, what I would say is you should send out a notice to your employees saying, look, we know we've had this tardicy or absentee policy. It's been in place for a while. We've been lax in enforcement. We're telling you now that this is a priority of ours. We are going to start enforcing this. So please be aware of that and be mindful of it, because consequences will result if it's not followed. And then from that point forward, you need to start being consistent in your enforcement, and that will allow you to address the problems that you might be experiencing under those policies. One of the other things, and I get this question a lot, this is, can you use your documentation? So, a lot of times we'll get calls from clients and they'll say, well, I've been keeping a record of what's going on, and this employee is a terrible employee. And the next question that we always ask is, well, okay, you may have been keeping record of it, but have you been addressing it with the employee? And if the answer is no, then the fact that they've been, quote unquote, keeping a record of it is largely useless. And that's often a very difficult conversation to have with our clients, because we want to obviously help them get to where they want to go with a problem employee. But, this gets back to all of the principles that we've been talking about today. If you're aware of alleged wrongdoing, you need to deal with it as it occurs, put yourself in a position to be able to support whatever action you might take down the road. Do you have witnesses that will actually testify? We talked about getting witness statements when that's necessary. And are you utilizing progressive discipline? Progressive discipline, I mentioned way back at the beginning of today's session, really deals with the idea that the disciplinary action that you're meting out should generally match the severity of the conduct. Now, that's keeping in mind several factors. Has there been prior discipline? That's where the personnel file comes in. You need to be aware of what prior discipline, if any, an employee has faced when you're making a decision about disciplinary action. So, even though progressive discipline is the general principle that you want to follow and should follow in order for you to engage in action that is supportable and defendable, keep in mind that if you have a 25-year pristine employee who has no disciplinary record, if they come in one day and snap and they punch their supervisor, well, that's likely terminable. And just because they didn't have prior disciplinary actions in their record doesn't mean that you shouldn't deal with what is a very severe event in a severe fashion. And what that would mean is either a lengthy suspension or a termination. So that takes us to questions. I appreciate your time today. I'm certainly happy to entertain any questions that you might have. And I would also say that if anything comes up after the session today that you'd like to ask about, please feel free to reach out to me, and I'll be happy to help you in whatever way I can. So again, thank you for your participation today.
All right, Sean, it looks like Eva Rose from Beaver Falls City had a question. She asked if, can you touch base on non-union employees for a second? Sure.
I tried to differentiate in the processes that we discussed today between union and non-union. And I hope now, and I believe this question came in a little bit earlier, I hope that perhaps your question was largely answered. Certainly Weingarten only applies in the union context, but as I said, the Garrity process and the Loudermill process, those can apply in a non-union context as well. All of the principles that I talked about relating to investigation, getting witness statements, and all of those things, those can also apply in a non-union setting. So if you are in a work environment where you don't have any unions, except for Weingarten, in that requirement that the union rep be provided, all of the other concepts that we've talked about today, I believe, would be helpful to you as you engage in an employment investigation.
All right. And it looks like, and as a matter of fact, her question did come in at the very beginning, so she probably did have that answered at some point. Also, Greg asked, is there a logical threshold for managers to approach a discipline case with or without legal representation?
Yeah, that's a good question. Certainly, doing what I do get calls from some clients who want to get their lawyer, their labor counsel involved from the very beginning. There are other clients who I have who will call me at the end. What I would say is if you have an ability to engage in an investigation following the dictates, the procedures, the things that we've talked about today in a way that is meaningful. So in other words, if they're familiar with what rights adhere to the employees, what abilities the employer has to procure information, because perhaps they've done it numerous times and perhaps they've done it in conjunction with competent labor counsel in the past, well then it's not necessary that a lawyer be involved at every stage. But if you're unsure, or it's been a while since you've dealt with an investigation, or maybe this is the first time you've dealt with a certain scenario, you know, for instance, if it's the first time you've ever had to do an employment investigation with someone who was potentially also engaging in criminal conduct, well, in those cases, just because there's so much at stake, I would normally recommend that you at least check in with your labor and employment counsel to make sure not only that you're protected, but that you're getting yourself in the position to go where you might want to go with whatever comes out of the investigation.
Okay. I think that's all the questions, Sean.
Okay.
I'm going to just close things up. Are there any last minute questions? You can type them in real quick if you have them. Okay, Sean, that was an incredibly informative webinar. As you stated to me earlier before we started, you did design it so it was packed full of information. Everybody will receive this copy of this webinar. Justin will send that to you so you can keep it handy as a reference. And I particularly like the summary you provided at the very end. It was very good and pointed out some mistakes that many managers make as they manage employees. So on behalf of Local Government Academy and all the participants, we'd like to thank you, Sean. We'd like to thank Campbell, Durant, Beatty, Palumbo, and Miller, and we definitely look forward to future webinars and classes from you and your firm. Any last comments, Sean?
No, I think that was it. I appreciate the opportunity, Greg. Thank you to the Local Government Academy. And, you know, like I said, if anyone has any follow-up questions, please feel free to reach out. My contact information will be on the PowerPoint, and, you know, you can reach me that way. So thanks again.
Okay. Thank you, everybody. Thanks again, Sean, and thank you, Justin. And we'll see you at the next webinar.